I'm Claire Cornell. I'm a partner in Finnegan Europe, so I'm based in London, and my colleague Aaron is from the Washington, D.C. office. We're
happy to be here. Thanks for having us. Hope not to put you to sleep. And I know everybody's getting ready for lunch, so we'll try to be kind of quick.
So I'm sure that some of you have attended the workshop with IncaPro, who will have told you lots of great things about dealing with IP issues in this sort of cyber world. And I think we're going to talk a little bit about how you can use your intellectual property as the tools to utilize some of this software and to help you deal with problems that you might be encountering, particularly in the digital and modern world where we're seeing lots of issues for IP rights holders. So what is luxury? We know that luxury is something people want. We've got quality, we have design, and this comes at a price point. And unfortunately, everybody wants a bit of that luxury, but not everybody can afford the price that might need to be paid in order to have a slice of the cake. And I think this is where some of the biggest problems that luxury brand owners are seeing at the moment is problems potentially with counterfeit products, copycat products. I'm not sure where our far right-hand slide falls into that, but that was a handbag that I saw somebody wearing on the street in Mexico City last year. Looks very Michael Kors, but it's not. But you know, these are real problems for brand owners. And one of the issues that I'm sure people are encountering is in relation to how easy it is to sell counterfeit products these days, and how the digital era has made it much easier for counterfeiters to engage directly with customers. So gone are the days where somebody's selling sunglasses on the streets where it's relatively easy to pick up tip-offs and see where people are. Now you have people engaging with social media, with online chat, and able to engage directly with a manufacturer, potentially in China, who can ship products straight to the buyer without really having to go through the normal channels or dealing with customs. They can rely on the mail, which makes it much more difficult for people to actually take stock of what's happening. We've got some figures here just at how big a problem we have in Europe with counterfeit products and the revenue that is being lost to counterfeits. I think one of the take-homes that we're going to talk about today is that it's important to protect your intellectual property and how we can use that as a tool in this era.
Yeah, so as Claire was saying, counterfeiting is a big issue. But we think of intellectual property as not just to battle against counterfeiting, but with respect to the counterfeiters that you're finding online and even on the street, you need to have your IP registered typically. There are some unregisterable rights, and we'll talk about those. But the key really to formulating and developing a fence around your intellectual property, meaning a way to protect your brand and your products, we view it as trying to come at it from various different angles. We want to develop a broad, diverse portfolio relating to intellectual property. So that's what we're going to go through. So it might be basic for some people, but we're just going to talk a little bit about the various types of intellectual property that are important or should be important for luxury brands and all brands in particular. But trademarks, right? Everybody probably understands trademarks are, protect the source of a goods or services. You typically think of brand names, right? Those are the most well-known trademarks. And step back one moment. In terms of developing the various types of IP, you also need to understand that laws are different in all countries. We have, I won't say all countries, but every country has a set of IP laws, and they differ. They differ from the US to the UK. They differ from the UK to the EU. They differ from, in Asia, Africa, South America. All countries have their set of laws. So, and this doesn't only affect what can be protected. It also affects when you need to register. For example, in the United States, relating to patents, if you come up with an idea and you want to share that at a trade show, for example, you have up to a year from the date that you've shared that invention at a trade show to file for a patent and to be able to protect that idea. But once I have shown that idea at a trade show, for example, anywhere in the world, I can no longer file for a patent in Europe or in China because as soon as that's public, you no longer have the right to obtain that patent. So these are the types of things that are very important to have a grasp of before you kind of start pursuing products. And we tell our clients all the time that the key is to register early, whether you're talking about trademarks, and we'll talk about some real world trademark cases where the time of registration was vital to who won and to who lost. So quickly, I mentioned utility patents. Utility patents protect the function of a product or a device, or also, you can get utility patents on chemical compositions, formulas, things like that. Not formulas, sorry. Design patents, that's what we call them in the U.S., and here they're referred to as registered designs, but those protect the way something looks. The ornamental design is the way that we think of it, as opposed to the functional aspect. And then there's also a set of rights called trade dress. That's what we call them in the U.S., and I think here it's very similar to what's referred to as passing off. But that's more to cover and protect the way that a product looks. And we'll go through some examples. That we don't want to get down too much in the nitty-gritty, but these are all things you should be thinking about. Is this a way? Can we protect our products, our trade names, things like that, using some of these types of IP? Others that we didn't include on the list, I'm not going to really get into today, are copyright, which everybody probably knows about, and then also trade secrets. But they're all relevant, and they're all something that you should think about early in your product cycle, and as you're developing a new brand, a new company. So, like I said, I mentioned trademarks, but we've got Nike, Levi up there. But any name can be trademarked. Again, the idea is to create and maintain your brand's identity, prevent consumer confusion, and prevent the dilution of goodwill surrounding your brand name. So that's why you want to register your names, relevant trademarks, very early. So trademarks can be broken up. In addition to just words that we were talking about in brand names, you can get trademarks on position. So the position of that little red tab on the back of that shoe, for example, you can obtain a registry or register for and try to protect the use of that shape on a particular location, on your shoe or on a shirt. And trademarks can also be shape marks. So three-dimensional objects, you can now trademark those. Slide number 3. So we mentioned trade dress, and trade dress, again, it's focused more on the product in the packaging. So you can actually obtain protection for the way that your product looks. The idea here is it needs to be distinctive and non-functional. So the maker's mark, whiskey bottle, for example. Anybody who probably recognizes that you see a bottle with that shape or that red wax, top, it came from Maker's Mark. So that's something that is an example of a right that can be protected through trade dress. Now, utility patents, and I'm sorry I'm going kind of fast, but if anybody has questions, raise your hand, please. We're happy to open it up. Utility patents can cover a wide variety of things, but like I said, it's something functional. So here you've got the functional aspects of this garment, but it's the way something works. And in the luxury market, utility patents, I would say, 10, 15, 20 years ago, maybe weren't that relevant. But as wearable technologies have increased over the last decade, we've seen a lot more filings for luxury companies relating to utility patents, trying to incorporate that technology into their clothing, their products, their jewelry, things like that. And also there are more and more utility patents being filed by relating to, like I said, chemical compounds, fragrances, things like that, cosmetics and perfume. And then the last one I think we mentioned was design patents, and that's to cover the ornamental look of a product or a design. And you can obtain design patents on the use of the color, but also just the look of that heel, for example. The last one for me, just to kind of point out how my point about understanding the laws in different countries and how that might affect you and your business. But this, I'm not going to go through this, but this chart just shows that the length of time that a patent may be in force varies by country, as does how you obtain that patent. We have a registration system, for example, means you just register your design, and no examiner at the patent office looks at it and determines whether it's new. You have that right. Whereas in other countries, there is an examination system where they may decide, well, someone had a very similar design before you, and they're not going to give you the patent for that reason. So these are just things that you need to be aware of.
Yeah, that probably was a bit of a race through if you're not familiar with some of the types of protection that's available for you. And I think that both the registered designs and the unregistered designs can be really useful tools for brand owners, particularly with unregistered design rights in the fashion industry, where we are able to put products on the market and obtain 3 years of unregistered design protection, which prevents copying. This can be a really useful tool for brand owners because you do not need to be investing in the cost of registering your rights, and yet it still gives you a degree of protection which will last for probably as long as your product will on the high street, where fast-moving consumer goods, fashion trends mean that you're not necessarily going to be selling the same product for years on end, so you don't want to be paying a huge amount of money, and you may have a vast portfolio of different products that you need protection for. So remembering that those unregistered rights exist is a great tool in your armor, your toolbox really to keep your rights protected. So how do we use our IP to retain the luxury image? I mean, we've got some fairly obvious points listed here. And I think particularly in today's discussions, we're talking a lot about what can be useful online. And I think one of the messages, education and informing not just your customers, but also customs, taking advantage of registration systems, not just with trademark registries, but also the verified owner programs that are available on the online marketplaces. You'll find that your customers are always very interested in protecting your brand as well, because if you've invested in a piece, you don't want to see rip-off copies all over the high street. So, make sure that you have available online reporting possibilities, or maybe an email address, or following your Twitter feed just to see what feedback your customers are giving to you, because they're your eyes, and they will be keeping an eye out on the brand for you. So taking advantage of that is a really great asset. One of the other things I've got written here is cease and desist letters, and that sort of opens a can of worms in itself these days with social media. I'm sure you've all seen going viral the cease and desist letters that some brand owners have been sending out to maybe smaller companies who might be taking advantage, or sometimes they're just very naive. So it's important to make sure that the press around your brand is quite positive. Certainly when we're dealing with people who are potentially infringing trademark rights, is not to always go with a heavy-handed approach if the publication of that letter could potentially cause you a little bit of embarrassment or some issues. So taking the strategy where you're saying, well, we understand that you appreciate our brand and we're very flattered that you've chosen to copy our intellectual property, but you must understand that this is also our business, and as such you need to step back because this is going to be received in a much better way if it's published on social media and starts to go viral. They say any publicity is good publicity, but we don't always want to look like we're the nasty, hard-nosed lawyers who are just out to get the small businesses or the new entrants to the market. So it's important in the digital age to tailor your approach to the particular audience that you're intending to reach. I'm not going to talk in any detail about the brand registration programs, but I think make sure that you are engaging with these. There's lots of great programs available to help brand owners to keep copycat products off online forums and to report infringing products. And that just takes me back to the education. If you're looking at products that are going to be coming in through customs, it's always great to make sure that your customs officers are familiar with your products. Go and train them. What do your genuine products look like? Get them engaged in looking for your products as they come through customs so that they can quickly and easily identify counterfeit products, get in touch with you and get those taken out of circulation before they get onto the market and start to do damage. I think from this point we're going to move on to talking about a few cases, some of which are US cases and some of which come from Europe, just to give you a feel for the outcome in situations where potentially you've registered a trademark or a design, or alternatively if you haven't done so, and what issues might come up in that situation.
So the first one we want to talk about the Supreme versus Supreme Italia, and many of you probably know more about the Supreme brand than I do. My kids knew a lot more about it than I did, so I got a little bit of help with the slide. But but seriously, if you're not familiar, Supreme started as a skate brand in New York City and has quickly grown. They've had collaborations with Louis Vuitton, Lacoste, Nike, Timberland. And so their trademark is essentially right there. It's a red rectangle with big block letters, white Supreme. And it's become very popular over the last several years, and now is one of the most counterfeited brands in the world. So a couple years ago, Supreme sued Supreme Italia, who I guess not surprisingly had adopted the same trademark and was using it in Italy and various other countries. But Supreme Italia had also, and this is what we're going to refer to as something that's called a legal fake, they had registered for the same trademark, even though they weren't the ones who came up with it. So they took Supreme's trademark, brand name and logo, and they registered it in Italy. Fortunately in this case, for Supreme, they had also registered in Italy, and it happened to be like about 1 month before Supreme Italia had registered the same exact logo. So ultimately they were successful, and they won a trademark infringement case in Italy. And not only did the court say, well, you were later, Supreme was here first, but they also kind of slapped them across the wrist and said, you just stole their trademark. This wasn't even new. And again, like I said, Supreme was able to be successful because their mark had, the court in Italy had held that their mark had obtained secondary meaning. I don't want to get into the nitty-gritty, but that's really how this should have gone, right? They developed the trademark, they registered it first in Italy. They should have won and been able to get Supreme Italy or Supreme Italia off the market. Now, the next case, more recently they sued Supreme Italia in Spain, and that was the end of last year. And in this case, the court in Barcelona actually ruled in favor of Supreme Italia, and that was because they had registered the mark first. So think about that. I mean, your company has developed this logo, and someone else copies it, goes and files it in another country, and even if you come in a day or two later, you could end up losing that case. If I mean, it all, again, like I said, the laws are different everywhere, and the way that the Spanish court analyzed whether they had obtained secondary meaning, I think, is probably part of the reason here. But they must have found that you didn't meet that standard, and because these other guys had filed first, it didn't matter that they copied it from you. So we see that a lot. It happens a lot. In China, we deal with it for our clients a whole lot, and again, I refer to it as a legal fake, and it's a problem. And that's why we implore our clients to be aware of where you think your products are going to go, where do you think your brand is going to be important, and register early. Yeah. I mean, I don't want to overstate the problem that is out there, but it really is, and we see it all the time. And this is a very good example
I think
of it.
China is probably everybody's biggest nemesis at the moment, and I read actually that the Supreme trademark is so popular that there have been 1,400 trademark applications to register the Supreme logo in China by all sorts of different applicants. And there are private individuals in China who are basically making a living out of registering other people's trademarks and holding them hostage. So in situations like this, even if you haven't gone to China yet, a take-home message is, get your application filed. And another trademark case that you guys might have heard of related to the Under Armour brand and the Uncle Martian brand, which was basically a copycat logo in China. The Chinese company launched identical products to the market, and the Uncle Martian logo is basically identical to the Under Armour logo. Under Armour had got prior registrations in that situation, so they were able to win that particular infringement battle. But the Chinese market can be notoriously difficult to crack and is potentially biased towards Chinese nationals. And obviously Chinese companies, Chinese individuals can interact very easily with the registration system and take advantage of that. And they're out there to make a living out of bad faith filings. Things are supposed to be improving, and the Chinese government and the Chinese trademark registry are trying to prevent these bad faith filings, and particularly give the trademark examiners the opportunity to look at the past filing history of a trademark applicant, and if they see that this applicant has potentially filed for hundreds or even thousands of other people's trademarks, that potentially refuse those trademarks on the basis of bad faith. But it can be difficult for brand owners to know which ones to go after. The game of whack-a-mole in China, where you knock one down and another one pops up somewhere else, is not just relevant for goods, but also for trademark applications and registrations, that you potentially take one person off the market and another one will jump up. So having the earliest trademark registration out there is going to be a really important tool for you.
And surprisingly, this happens in the patent world as well. We had an issue with a client in China who had not filed patent applications in China. They just thought, oh, well, they won't be able to enforce them in China. But what happened was somebody came with a knockoff in China, and they filed patents with the exact drawings that our client had used in their U.S. applications. And so basically the point was that it became an issue for them when they wanted to try to get the counterfeit off the market in China. They had trouble because the other people already had rights, whereas our client was going to come in and trying to assert no rights because they hadn't filed in China. So it is definitely a problem. Let's skip this next one. Now this is a U.S. Yeah, that's okay. So the only thing was mentioned about this case, it was a design patent issue in the U.S. for UGG boots. It's owned by Deckers. And the reason I thought this one was important is it just shows the importance of having multiple layers of protection. Because in this case, I guess focus on the one in the middle against Romeo and Juliet, they settled a dispute relating to the trade dress. But then the court found that their design patent case that UGG then had against Romeo and Juliet could still proceed. So it's kind of interesting. The point is that the trade dress rights did not preempt design patent rights, so they could sue both on trade dress and on design patents. And so it's interesting to understand those the intricacies of the law and be able to kind of, again, like I said, build that fence. Do you want to briefly talk about that?
I think really the take home here is do combine the rights that you're looking to register, and in many cases of infringement, you're not just restricted to bringing one ground. You can bring a case for passing off in parallel to a trademark infringement, potentially in parallel to a design infringement. So it's important that you spread out your rights and make sure that you have everything covered, because this could be the key for your success in an infringement action.
Yeah. All right, thank you.